Get ready. Start. The applicant filed IA number 1 under section 9 of Arbitration and Conciliation Act, read with full point. 39 Rule 1 and 2 and Section 151 of CPC, praying for passing ad interim order clause A, suspending the operation and effect of letter dated 1/6/2022 issued by the respondent, terminating the business operations on day-to-day holding over basis, clause B, restraining the respondents or any of its officers, agents, servants and subordinates from creating any third party rights or in any manner appointing new dealers, distributors in areas of business operations of applicant pending arbitration proceedings between the parties, clause C, restraining respondents or any of its officers, agents, servants and subordinates directly or indirectly, pursuant to the letter dated 1/6/2022, terminating business operations on day-to-day holding over basis from in any manner acting and carrying on any action which would be detrimental to the interest of the applicant, pending arbitration proceedings, clause D, to direct the respondent to restore and resume business operations with applicant in the territories of operation and operation facilities as they were existing prior to 1/6/2022, pending arbitration proceedings, and clause E, to grant such other orders as this honorable court deems fit, in the interest of justice and equity, full point, in the accompanied affidavit The applicant has contended that the applicant company was founded by Mr. Maganti Subramaniam, who had started car shed business as a sole properties proprietor in the year 1962 full point. In the year 1972, he was awarded the dealership of Kirloskar Oil Engine and Kirloskar Cummins diesel engines full point. Thereafter, in the year 1984-85, he was awarded dealership from Messrs. Maruti Suzuki owing to consistent results achieved by him in the past full point. In the year 2000, Mr. Maganti Subramaniam was awarded dealership from respondent, that is Mrs. Toyota Kirloskar Motors Private Limited full point. Pursuant to it, he resigned as a dealer from Maruti full point. That Mr. Maganti Subramaniam left his lucrative business with Maruti Suzuki based on non-negotiable condition issued by respondent, stating that he should have a dealership with respondent alone full point. That Maganti Subramaniam, through his partnership from which Radha Madhava Automobiles has allotted a non-exclusive provisional dealership wide letter dated 9/10/2000 received from respondent for carrying out business on provisional business in the city of Vijayawada full point. As per terms of letter dated 9/10/2000, 4 companies which Leela Krishna Automobiles Private Limited, Radha Krishna Automobiles Private Limited, Radha Madhava Private Limited, Yashoda Krishna Automobiles Private Limited were subsequently created for carrying out the dealership business of respondent company and later on came to be held by a company called Mrs. Krishna Priya Automobiles India Private Limited. Full point. The dealership agreement was duly executed between applicant company bar other Radha Group companies and respondent. Full stop. The said dealership agreements were renewed from time to time. Full point. The latest agreement executed between parties is dated 25 to 2016 and its subsequent renewal dated 13/3/2017 and 1/8/2018, came to an end on 31/5/2021, Thereafter, the agreement was extended on an understanding that fresh agreements will be directly executed with proposed new companies, pursuant to the proposed restructuring of the group companies. Full point. Stop.